This is a recording to accompany our discussion of amount and controversy, which will begin in class on Tuesday. Um, while you're listening to this recording, you want to download or print off a copy of the amount and controversy handout that you'll find on TWEM. As you follow along with this recording, you'll be able to answer many of the questions on the worksheet. Once you finish those and this recording, you'll upload your answers into the appropriate box on TWEN, and there's instructions on TWEN to help you with this. At the end of the worksheet are several hypotheticals that I plan on covering in class. There's also a corresponding quiz on TWEN that you'll want to include your answers before class. There's also instructions about this on TWEN as well. My goal here is to spend time on those questions that are causing people more difficulty and summarize the questions that most people got right. So it allows me to adjust how much time we're going to actually spend in class on this topic. Amount and controversy is well suited for this type of format because it's actually very, very straightforward. So let's look along with the PowerPoint presentation. And again, like any of these, if you have any questions about this material, it's completely fine to ask me before class or even during class. I'm always happy to continue coverage of this in class. Simply because we have a recording does not mean that I won't cover it in class. So just let me know what you'd like to cover. Okay, both diversity of citizenship and alienage jurisdiction have an amount in controversy. If you look at the language of Section 1332A, it says the district courts shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs, and is between, and then it includes the language of citizens of different states, and between a citizen of a state and foreign states, and in subsection 3 also the other provisions of alienage. But because this is in the header in Section A, it means that the amount in controversy language applies to all. We've already mentioned in class that the Constitution doesn't actually have an amount in controversy requirement, and that Congress has put this on the limitations for federal court because it wants to limit how many cases can actually make it into federal court. To understand amount in controversy, there's basically three large issues that you need to understand. One, what type of remedies are actually available to you in court? Secondly, and the one that has the most material with it, how do you actually know or determine if the remedy you seek satisfies the requisite amount in controversy? And it has three subparts. The one in red here, what can you count to reach the amount, is more complicated, and while I want you to work on that in the worksheet, that's the one we're going to spend most time in class on. And finally, how is the amount in controversy element of subject matter jurisdiction challenged? In other words, if you believe that the party is actually not able to make the amount in controversy in this dispute, can you challenge it to keep them from filing in federal court? All right, so the first issue is what types of remedies are actually available in lawsuits. And to understand that, let's look at a hypothetical here. Dan worked for Summer Fun Vacations for 15 years as a tour director. Summer Fun Vacations has spent large sums of money and has invested significant time to develop a client list, marketing information, and tour information for its tour packages. Dan quits and decides to create his own tour business to compete with Summer Fun Vacations, and Summer Fun sues Dan for misappropriation of trade secrets. What types of remedies can Summer Fun Vacations seek? And if you're representing Summer Fun Vacations, it might become obvious to you that there's certain kinds of things they might want in this kind of a lawsuit. One thing that might come to your mind first, and primarily because we discuss it most in law school in your first year, are damages, both compensatory and potentially even punitives here, whether or not you can receive punitives are spelled out by law, and we'll get into that a little bit in class. But damages, wanting some sort of remedy in the form of money relief. And knowing that you want damages will dictate whether or not you meet the amount in controversy. Because the amount in controversy language is spelled out using a monetary figure, it's a little bit easier to see how that might actually fit within the language. But there's other forms of remedy that you might be seeking in court, and it might pose a little bit more of a challenge for us in determining whether that also meets our amount in controversy. Namely, Summer Fun Vacations here might want an injunction. For example, they might want to get Dan to stop using the information, to enjoin him from the ability to use the information because they consider it to be their own and that his use is in breach of a contract, potentially with him before. So that might be something they're seeking. And if you have an injunction, then the question for federal subject matter jurisdiction is, well, how do you determine what that actually amounts to when you're thinking about the amount in controversy requirement. And lastly, declaratory relief is another potential option we might want here. We're not going to focus on that for the purposes of our class, but it's something that we are going to return to later. So just consider it now that they might want something like a statement that the information is in fact their trade secret. That would be a declaratory judgment, where all you get is that statement, the judgment saying, yes, this in fact is your information. All right, so now that we know all the types of remedies that are available, it's important to get in that next big question. How do you determine if the remedy you seek actually satisfies the amount in controversy? So what is the requirement? We looked at the language a little bit ago, and it actually is over 75,000. In 1997, it was increased from 50,000. It's been increased a couple times, and it might increase again. Often Congress will tighten the ability for people to use diversity jurisdiction by using this aspect of it, the amount in controversy aspect. Let's assume the plaintiff is alleging injuries that amount to exactly $75,000 after a car accident. Would this satisfy or meet the amount in controversy requirement? Well, if you look at the language in the statute, it wouldn't, because it says where the matter in controversy exceeds the summer value of $75,000. So meeting it exactly on is not sufficient. 1 penny more and you're okay. It has to exceed it. Let's consider another permutation here in this. We've got plaintiff who's injured in a car accident caused by the defendant. Because it was only a minor collision, he suffers a small bump on his head. Plaintiff, however, has decided to hire the best lawyer in town. Plaintiff's expenses related to his injuries total $25,000. Plaintiff's lawyer, on charging plaintiff, plans on doing that of $60,000 to represent him because he's the best in town. Is there diversity jurisdiction based on the fact that the total expenses to plaintiff will be $85,000? So $25,000 for his injuries and $60,000 for his lawyer bills. Can we get to over $75,000 by adding the $60,000 and the $25,000? And the answer is no, because the statute tells us it's exclusive of interests, which are things that can accrue on judgment, either pre or post judgment, and costs, including things like an attorney's fee, cannot be included to decide whether or not you reach the amount in controversy. All right, one other issue related to this is what if you don't actually recover over $75,000? If you remember from our Moss v. Perry, our very first case, Mr. Moss, this was actually an issue in his case, and the casebook author edits a lot of this out of the opinion, but there's a reference to it in there. Mr. Moss pled that his claim exceeded the amount in controversy, but he only actually recovered $10,000. Apparently the jury felt like that Perry was primarily watching his wife, or that he didn't suffer as much damage as she did by the observations through the two-way mirror. We don't really know, but he didn't recover the amount over 75. So does that matter? Does that deprive the court of does that deprive the court of subject matter jurisdiction over his claim because he didn't actually recover that when the jury rendered its verdict? The answer is we still have SMJ. We still have SMJ over his claim. So how do you know whether or not you meet the test for amount in controversy, or what kind of standard are we going to put towards the pleading requirement, Mr. Moss pleading that he's actually going to be able to recover it? The answer is that they have to claim in good faith that they are going to be able to receive a greater than $75,000. Now keep in mind at the time that Mr. Moss pled his claims, the amount in controversy was much lower, around $25,000. So it was easier for him to reach at that point in time. But the issue is what kind of pleading basis do they have to have, and the answer is at least a good faith basis in claiming it. So that would prevent someone from just automatically claiming every single time that their complaint amounts to over $75,000 just to try and reach that amount in controversy. Is there any consequence if you don't recover the 75,000, so you're Mr. Moss and you don't recover the actual 75,000, is there any consequence to you, or is it simply you're going to be fine? Well, the answer is actually included in the statute in 1332B, and it allows the court to either deny costs to plaintiff and order the plaintiff to pay costs to defendant if they in fact don't actually recover over 75,000. That doesn't happen very frequently, but the statute permits the judge to do that. So there is a potential penalty to not recovering over $75,000. While not used very often, it's there, may deny costs to plaintiff and order the costs to be paid to the defendant. But in actuality, it's the good faith basis. As long as you have that, you're okay. Well, either way, it will not strip the court of subject matter jurisdiction as long as you have a good faith basis for pleading him. Now realize the opposing party can always challenge your good faith basis, and if you can't prove up that there's a likelihood that you'll get over 75,000, then the court can dismiss for lack of subject matter jurisdiction, where you have your triggered burden of proof to defend that. What can you count to reach the amount? Well, we're going to look to the type of remedy, and for that we're going to do most of this in class. So the worksheet asks you to look at when you're using damages, what kind of rules do we get to decide whether or not you actually hit over 75,000, what can we count, what can we add, and then if you're using injunctions, what kind of tests are we going to use. So look for the through the case and through the readings, the notes after the case and the reading, to decide what the standards are for damages and for injunctions, and answer those hypothetical questions and transfer your answers over to the twin quiz. If you have any questions, feel free to ask me.